This really is a historic moment. I don't know that there has ever been a case in the past century that the Supreme Court has heard 3 whole days of oral argument, a total of 6 hours of oral argument. Pacific Legal Foundation has been the most active organization in the country in opposing various aspects of the Patient Protection and Affordable Care Act. Not just the individual mandate, which is the portion of the law that gets most of the attention, but this law also imposes expensive new mandates on states to provide Medicaid, which is unconstitutional under the spending clause of the Constitution, and it creates an agency, the Independent Payment Advisory Board, to regulate spending on Medicaid, which is unconstitutional because that agency is totally independent of control from the President, the Congress, the courts. It's an amazing delegation of power. Again, an unprecedented attempt by Congress to basically give away its lawmaking authority. So Pacific Legal Foundation has been involved in all of these cases, challenging all sorts of different aspects of this massive new federal program. The individual mandate is an expansion of federal authority under the Commerce Clause like nothing we've ever seen, in principle, because in previous cases, every previous case, what the federal government has said is, if you're going to engage in commerce, you have to do so in this way. And that's a regulation of commerce. And we can argue over whether or not Congress had the authority in that particular case to impose that particular type of regulation. But never before has Congress asserted the power to force you to engage in commerce in the first place. And what the individual mandate does is it says the federal government can force you to buy a product or service that officials in Washington, D.C. think is a good idea for you to have. And if that's something Congress has the constitutional authority to do, where does that stop? I think there is a strong legal argument on the other side. I'm not saying that this is a totally unreasonable argument. The problem with that argument is that it doesn't provide any principled limits to federal authority. And that's a point that the Obama administration has still never been able to answer. In well over a year of litigation, the Obama administration has never been able to say, under its legal theory, where federal power comes to an end. Arguing that health insurance is just a different type of market, that everybody needs health insurance, therefore that health insurance should be treated differently as a legal matter, is really an illusory sort of principle, because every market is different. Every market is different. Everybody needs shelter, everybody needs transportation, everybody needs food. You could make all these kinds of arguments, and you could make economic arguments that say this market is unique or that market is unique. Those are not legal limits. Those are not principled limits on federal authority. The Constitution was created to give principled limits on federal authority, to say the federal government can only go this far and no farther, to allow the federal government authority whenever it thinks economically that it would be a good idea, or whenever it can make an economic argument that this area of the economy is special for some reason, really would not provide the kind of principled limits on federal authority that the Constitution requires. You know, ever since its founding in 1973, Pacific Legal Foundation has been very concerned about the federal government's exploitation of the Commerce Clause. From our earliest days, we've been opposing federal expansion of its own authority, which has usually taken place on the grounds that, well, such and such has some effect on commerce, therefore we can regulate it. And of course, that kind of thinking has led to federal control over practically every aspect of our lives, to the point where today the federal government sets rules on everything from the thickness of ketchup in fast food packets to the design of furniture in your office building. And that has all been done under these absurd stretches of interpretation of the Commerce Clause. We file our amicus briefs as a way of speaking to the courts on behalf of people who otherwise would have no opportunity to have their voice heard in the most important constitutional case to come along in well over a generation.